At 2 points during the presentation, I will pause. For those of you who are seeking credit for CAI, we have been asked to provide some codes to the participants, and then at the end of the presentation, I'll need you to email those codes to Terry, and she can provide you with that certificate of completion for your credit for today's class. So I'll make it very clear. I'm not going to just slip it in there. We will pause and give you every opportunity to write down that code if you need to. So, all right. Well, let's jump in to this presentation today. We decided as a firm to, in light of the recent change in the law in Arizona, and quite frankly, in light of some questions that I've been receiving and other attorneys in our office have been receiving, we thought it would be good to try to tackle this issue of marijuana, and it kind of fits into that broader issue that I think in any of you who are living in a condominium or a townhome with shared walls or managing one of those communities, you're probably presented with that issue of smoking, smells going in and out of people's units. And so we are going to talk a little bit about that. That kind of opens up the discussion to a more broad discussion of what can we do with that. And I think marijuana just kind of jumps right into that conversation. So full disclosure, I'm probably the last person on the earth who you would want or who would have the information about marijuana. I am not an expert in this area. But I do feel that it's important to bring this up for community associations because I do foresee these issues coming into your communities from various owners. So we're gonna tackle today. Let me go to my next slide here. We're gonna go over this new law that has made recreational marijuana use legal here in Arizona. We're gonna talk about some of the exceptions, some of the things to be aware of. Now, I have asked Terry to provide you with an actual copy of the bill. If you are kind of that glutton for punishment, you want to try to read the whole bill, have at it. It's 16 pages, and we're not going to talk about more than maybe 2 or 3 pages of it today. But you should have that. If you don't, just send Terry a quick message, and she can try to email that to you if you want to follow along. There's also a handout that's coming with this presentation just for future reference. So we're going to talk about the new law, and then that will segue into kind of a more specific discussion about how that's going to impact potentially your communities, your roles as board members or managers, and what are some of the options that you might have to address this if it becomes a problem in your community, and some other legal concerns, including a discussion on fair housing. And then there'll be a time at the end for any questions or further discussion. So before we jump into the state law, I want to make it clear that the federal law has not changed. There's still what's called the Controlled Substance Act. Marijuana is still in that and listed as one of those controlled substances. So on the federal level, it still is technically illegal. Now, whether or not the federal government enforces that, I think the Obama administration, if I remember reading, they had made a decision at some point that they weren't really going to enforce that too strictly. I can't remember what happened during the Trump administration. I don't know, but on the books, it's still on the books under the federal laws. But as you know, more and more states have now kind of taken it upon themselves to enact state laws, kind of governing at that local level in addressing this issue. So we have what's called the Smart and Safe Arizona Act. That's the I laugh when I read that, but that is the title they gave this bill in this new law that came out of Proposition 207. Now there is a video. We're not gonna watch this video. I've decided I'm just gonna kind of move past that. It's a video that the channel 12 released when. Actually, you know what? We'll watch a little bit of it.
Arizona going green. Voters hashing it out, passing Prop 207, legalizing recreational marijuana for anyone 21 and up, allowing Arizonans to possess up to 1 ounce and grow up to 6 plants. We are so excited for the community. Ali Marconi of Soulflower Wellness Center, a dispensary in Tempe and Sun City, says excited Arizonans are already showing up, hoping to buy. But Marconi says they need to slow their roll. We are an instant gratification type society. So when we hear that something passes, we want to get our hands on it right away. So it will be a little bit more time. Arizona's Department of Health Services will start getting applications for dispensaries in January. So to be blunt, experts say March is the earliest buyers without medical marijuana cards can purchase pot. This 17-page initiative is like a framework. The proposition allowing for one dispensary for every 10 pharmacies across the state. After hashing out the numbers, that means because there are already 120 existing dispensaries, there's room for only about 10 more licenses. There's no room for additional facilities to be built, except for a small provision in the law, which allows for 26 social equity licenses to be issued by DHS. Prop 207 also allowing for those convicted of certain weed-related crimes to petition for their record to be expunged starting in July of 2021. Experts saying the 16% tax is one of the high points, estimating up to $300 million in new revenue every year, dollars that will go toward community colleges and police and fire departments. All in all, it's a great victory. And as for your boss, they call the shots. They can still discriminate and drug test. Bianca Bono, 12 News.
I kind of like that last part there, because that is going to be kind of what we rely on as associations in dealing with this. But if you look at the bill itself, from that proposition, it is kind of interesting. The first part of the bill talks about all the money. I wasn't aware of this, but before this bill went into effect, there was actually a fund that had been set up when they made medical marijuana legal years ago, and part of this bill is they're now transferring close to $40 million from that fund into various organizations. Arizona Teachers Academy, Department of Health Services got a bunch of money when this new bill passed. Just a little side note there. But the actual meat of the bill that we want to focus on, and I'm just looking down at the bill to make sure I don't miss anything. It's kind of interesting too, as those of you who are familiar with statutes. A lot of the statutes will have a small definition section in the beginning. This has a almost 2 pages of defined terms that are used throughout the bill, which I thought was interesting. But the key points of this bill have to do with this ability to use marijuana now on a recreational level. I don't have a screen that goes over the details, but you should have received a handout from us as well that kind of goes over it. So anyone who's 21 and over is now allowed to possess, consume, purchase, process, and manufacture or transport 1 ounce or less of marijuana. Now, I don't know exactly what that equates to as far as a visual of 1 ounce, but they are allowed to up to 1 ounce to do that. In addition, they're allowed to possess up to 6 marijuana plants for possession, transportation, cultivation, and processing for use at the individual's primary residence. So that's where it kind of brings us into the conversation. Now we're talking about them doing it at home. The law also says that it says they can possess, process, and manufacture the marijuana produced by the plants on the premises, whether the marijuana plants were grown, if the following apply: no more than 12 plants are produced at a single residence where 2 or more individuals of at least 21 years of age reside. So there's these 3 requirements here if they're going to do it at home. There's that first one: 2 or more individuals residing at 21. Cultivation takes place within a closet, a room, a greenhouse, or other enclosed area on the grounds of the residence, equipped with a lock or other security device to prevent access to minors. And then the cultivation takes place in an area where the marijuana plants are not visible from public view without the use of binoculars, aircraft, or other optical aids. So owners have the legal right now to use marijuana on their property and to cultivate and grow marijuana on their property with these certain, as long as these certain conditions are met. But some of the stuff that kind of sticks out to me as far as associations are concerned, one is obviously the activity that's going to be taking place, could be taking place on owner's property. But these conditions that have to be met, that they're going to have this right to do it in a greenhouse or in some other enclosed area, as long as it's not visible. You know, we talk about, a lot of our documents have that defined term of visible from neighboring property. And I immediately thought of that when I read this. But you know, you have these conditions that owners are going to have to meet to not be subject to some sort of a penalty under the law. There's also language in this law about transferring marijuana between individuals, that they're allowed to basically trade the marijuana. You can't sell it. There can be no enumeration, remuneration, I should say. There should be no exchange of money for the transferring of the marijuana. And going into the next, the part that I think we really are concerned about is that the act does not prohibit a private entity that controls or owns property from prohibiting or regulating conduct otherwise allowed by this act. So there's very clear language in this bill that makes it so that associations are still able to control what takes place on their property, that they either own in a planned community or that they control in a condominium setting. And it also says that this law does not permit owners from smoking marijuana in a public place or an open space, which is defined in the act. So those last two things, I think, are the real important ones for associations, in that we haven't lost control of that. So, you know, part of me in preparing this presentation, you know, this may not be something that really affects your community, because you may already have rules in place or restrictions in your documents that already control this, and you may already have a pretty strict no smoking policy, and none of that's going to change. You're still going to be able to go forward with that policy, and now it would include marijuana smoke. Now the defined, let me just see something here. The defined term, it says smoking marijuana in public, but smoke is actually defined as inhale, exhale, burn, or carry or possess any lighted marijuana. So you have the other thing to consider, though, is marijuana comes in different forms. The cannabis, you have sometimes referred to as edibles or other types of marijuana that comes into play here. But as far as the smoking is concerned, that's what we're focusing on today, is that you still have that ability to control that activity. So that is kind of in a nutshell the new law that's in place. Like I said, there are a whole bunch of other pages with this act that go into the different violations, penalties, licensing requirements for dispensaries, things like that we probably aren't going to be too concerned with as an association. I guess there might be a situation if you have a commercial condo setting, you might have a dispensary, and there might be something to worry about there. But for the most part, it's the individual behavior that we're focusing on.
You may want to catch up on the PowerPoint. You're still on the second slide, I think.
Am I on the video slide here?
Arizona going
Yes.
green.
Yeah, I know, that's where I want to be.
Sorry about that.
So, and Terry's right. I could have jumped forward to this next one. So the kind of the meat of this presentation is I want to get into kind of the application of this. What does it mean? How is it going to affect us? And more importantly, what can you as a board member or as a manager in educating your boards, what can associations do to enforce against this issue?
We do have a couple questions.
Yes.
The first one is, would this have to be in the CCNRs, or can the board make a resolution or rule?
Perfect question. You beat me to the punch. It's, if you could hold off on that one, I will answer that question in, I think, 2 slides.
Okay,
So that's right where we're headed.
and the second one was smoking in someone's backyard versus in common areas.
Well, is the question whether just kind of comparing the two?
That's all it says.
Okay, all right. Well, we'll talk about that as well in I think another slide or two, because part of this discussion here, as I say on here, the association's ability to address issues and enforce the documents. This goes to I want to just quickly talk more about kind of the broader topic of enforcement. As all of you, I'm sure are familiar, your ability to enforce is governed by the governing documents and the legal authority that's presented in there, as well as the statutes, the Planned Community Act, Condominium Act. The enforcement in those statutes is typically limited to the ability to impose fines for violations of the documents. But it all stems from the documents, because the documents do 2 things. First, the documents will establish what you can and can't do in your community, on your property, in your backyard, in your house, in your unit. That's all spelled out in your CCNRs and your rules and regulations or your design guidelines. You know, all those governing documents are going to spell out what restrictions are there. And then the other thing that the documents do is then it gives you the right, and this kind of segues into the bylaws as well. You might have the authority as a board that might be found in your bylaws, but you would look to those documents to figure out what options you have to actually enforce those restrictions. Just saw a chat here pop up. So the thing you first need to look at when we're dealing with this is what do our documents currently say? What is it that is restricted in our community? And I will be willing to bet that almost every set of documents makes 0 mention about marijuana. I don't think I've read a set of CCNRs that specifically calls out marijuana. Most, as you know, most CCNRs give the more broad terms of activity. You might have language that talks about smoking if you are a non-smoking community. But you probably are going to need to look to other sections of your documents, such as the nuisance section, or some sort of odor or smell or activity that disrupts the quiet enjoyment of someone else's use of their property. That's the most common provision. You would also look towards the end of your CCNRs in the enforcement section. Sometimes it's titled enforcement, and see what rights you have as an association in enforcing your documents. You know, you'll want to look to see if you have the duty to enforce all violations, or if you just have the right to enforce as you deem appropriate as a board. That's a very important distinction in the enforcement provisions, this duty versus an obligation and right, the duty versus a right to do it. So that's kind of where the first step in this analysis is that as a board, as a community manager, you need to look at those documents, know where you stand. Because as this issue starts to present itself in your community, assuming that it does, you need to know where you stand so that you know how to act. And we're going to get into this. You may want to, or you may need to take the position that, hey, we need to amend our documents. We need to change what it says in our CCNRs or what it says in our rules to allow us to be better equipped to handle this issue. So along those lines, like I mentioned before, I'm going to go to the next slide here. Most of your documents, I haven't found very many that don't have this. Most documents in your use restrictions will have a section that deals with a nuisance. And it will say something to the effect of no loud noise, no odor, no activity, or any other activity that would be deemed a nuisance as determined by the board shall be allowed to occur on the property, or something along those lines. the question that is presented to me quite often, because I'll get a board member that calls me up or a manager and say, hey, this is going on, we think it's a nuisance. There's kind of that $25,000 question of what is a nuisance? When does something become a nuisance? It varies depending on the state you're in, but here in Arizona, there isn't a whole lot of case law on what's called a private nuisance. That would be an action taken by one homeowner against another for interfering on the property. But there's kind of a general idea I want to give you of the legal requirements that a court would look at, that attorneys and the clients would have to prove to establish a nuisance. So a nuisance is something that adversely affects or interferes with a neighboring owner's use of their property. That's the first key, is you have someone who owns property and there's something going on a neighboring property that interferes with that person's use of their property. And then the analysis is the activity or the occurrence has to be substantial, it has to be continuous, and it has to be unreasonable. Now, those are words I know if you've attended any attorney or law firm class, that whenever the word reasonable is presented, you kind of throw your hands up. I'm not quite sure how to define that, but that's what the court looks to. And if you drill down into some of those factors, other things that the courts will look at will be how offensive is the activity, what's the inconvenience level that's being presented, and you'll also want to see what kind of damage has been suffered. Is there measurable health damage that the person has suffered, or did they have to move out, live somewhere else? There's a lot of factors that go into that. So kind of the takeaway on the nuisance is just because you think it's a nuisance, clearly it doesn't make it a nuisance. And just because one person might be a little annoyed by something that their neighbor is doing may not rise to the level of a legal nuisance where there's actionable, it's an actionable claim that can be made. So I know we throw that word around a lot in this industry. I've written dozens of cease and desist letters and enforcement demand letters claiming that whatever's happening on the property is a nuisance. But I haven't had to take any of those to court and have a judge agree with me that it is a nuisance. Most people just comply, or it just kind of resolves itself. Just know though that if there's an action that needs to be taken in court, there is a kind of a high standard that's going to have to be proved for it to be established as a nuisance. So two cases I actually read about, this morning. They're not in Arizona, but it's kind of interesting because the question that I presented up there is, is secondhand smoke considered a nuisance? I didn't find any cases in Arizona. If any of you are familiar with one, please let me know. But I did see a case out of Florida where a non-smoking resident, actually this wasn't an association bringing a claim. This owner actually took her neighbor to court over the smoke that was coming into her condo from her neighbor. And the lawsuit that she filed, she alleged that it was a nuisance. She also alleged that the owner's smoke was trespassing onto her property, and that it was affecting her quiet enjoyment of the property. And the court in Florida agreed with her that the secondhand smoke was a private nuisance, and awarded her $1,000 for her damages. In a case in Boston recently, this is a kind of a different setting, but it's still I think appropriate. A couple was evicted from their unit for the smoke, and the same sort of analysis took place, that the smell that was created to all these surrounding units was a nuisance, and they were in violation of their lease agreement, and they were able to be evicted over it. So I know that's a small sample, but I've read other places where in some states, like in California, secondhand smoke is considered a toxic contaminant, and it's in their statute. And in Utah, tobacco smoke has been written in as a private nuisance in their laws. Now, Arizona doesn't have anything similar to that. They have the Smoke-Free Act, but I don't think it goes that far as to define smoke as a nuisance per se. But I think everything has been trending this way for years. The health impact of secondhand smoke, whether it's marijuana or tobacco, Both of them have negative health repercussions that I think most courts would agree that a secondhand smoke would be a nuisance. Now, as I said before, there are a lot of facts that have to be established. There's factors, there's things that are going to have to be considered. But that nuisance language that's in your CCNRs, I think could be a pretty powerful tool when it comes to smoking and concerns that are raised in a community, or mainly in a condo. It's probably not as strong of an argument in a planned community, but in the condo setting where everyone is on top of each other, it is going to be a stronger claim for you. Now, let me take a break here for those of you who are seeking CLE credit. Just have your ears perked up here and write down the number 420. And then I'm sure you can understand why I chose that number. Just trying to be a little humorous, but 420 is the first code for your CLA credit that you can email to Terry after the class. All right. Now that when we're talking about enforcing, like I mentioned, the nuisance language is probably going to be one of the only tools you have currently in your documents to try to address this issue that comes up. And I don't know how many, if we were in person, I would probably ask for a show of hands of how many. I would have started first by asking how many of you are in condominiums or close quarters. But I'd also be curious, how many of you have experienced this problem in your community with smoking, not necessarily marijuana, but just smoking in general and the problems that come with it. I know I think I have at least one or two projects on my desk right now that deal with this, but I don't think it's uncommon in those settings. So, but you have this nuisance language, and you should be able to rely on that to try to address it. Now, there are other things that we can do, and that's what I want to get into next. Is your documents. Before I go to this slide here, your documents may be lacking in information, and you may not have that proper authority. Now, before I jump into some of these revisions, let's make sure we understand the two main documents that we're dealing with here. You have your CCNRs, which, as everyone knows, the CCNRs. What's the main purpose of the CCNRs? Well, it's to control what activity takes place on the property. It's a document that's attached to the property. It runs with the land. When you sell your house, no matter how hard you try, you can't get rid of your CCNRs on your own. They go with you. And so the new owner buys a home, and they're subject to whatever's in your CCNRs. Now, when it comes to rules, that's going to be your other document that we're going to talk about. What are rules? Well, rules are a creation or kind of a side document that arise out of your CCNRs. Most of your CCNRs will have a section, usually around Article 4, 5, or 6, that talks about the association's ability and authority to create rules and to amend those rules. It's not something that has to be sent out to the homeowners. But you have to be very careful with your rules, because your rules can be limited in their scope. Your CCNRs may say that you have the authority to create rules that govern your common area. And that's it. It may just say that you have the authority to govern the common elements in a condominium. Or the rules may say that you have the ability to create rules that govern the entire property, with a defined term of property being the entire community. And that's the most that's the broadest language that there is, and that can be good when it comes to something like this, is that you could just through a set of rules, you might be able to impose new restrictions on certain activity. Whatever you decide to do with this issue, I would recommend that you talk to your attorney, whoever is representing your community, and walk through it with the attorney, because the last thing you want to do is to impose some restriction that maybe you didn't have the right to do, and then you start enforcing it, and it can create a whole bunch of problems. So just kind of on that, take that away from this presentation, that CCNRs and rules are the documents we're going to be talking about. But if you wanted to use the rules, Just make sure you have your attorney helping you with that, because it can get a little tricky. So on these next couple slides, excuse me, we're going to talk about I'm going to give you some ideas that you might consider. Some language, some provisions that if your documents don't have this right now, you might consider it if this really is a problem. Now, keep in mind, like I said before, you might be restricted in the ability to put some of this in place. If it is a CC&R requirement, as most of you I'm sure know, that is not an easy thing to do. And in some cases, it may be almost impossible if you're in a condominium, and we'll talk about that. But this is just some ideas to consider if your documents are old or need to be updated to address new concerns. So the first one we'll talk about is imposing some sort of a ban on all forms of smoking. This is enforceable, but it has to be done properly, and it might be limited in kind of the location and the scope of the ban. I've had many clients that are condominiums come to me and ask, where can we ban smoking? What can we do? And like a lot of attorneys will tell you, it depends on what your documents say. But your documents, if they're written correctly and properly enacted, they can put certain bans on smoking in all kinds of locations. I have read of, I don't know that I have any clients that are condominiums that have an outright ban of smoking inside the units. If any of you have that, I'd love to hear it, and to see how that works and what kind of problems that you've had. I'm not aware of any of my clients that have a 100% ban on smoking anywhere in the community. Most of my clients will come to me and say, we'd like to ban smoking because we're getting these complaints that homeowners, their neighbors are causing problems. And so we'll try to restrict the smoking on the limited common elements, which would be the balconies and the porches. Now, with limited common elements, a lot of your documents will say that owners have the exclusive right to use a limited common element subject to any rules that the association creates for those common elements. So,
Quinten,
yes.
Natasha says that they have 100% ban on medical/non-medical marijuana in their community.
Ooh, Natasha, can you hop off mute and we can chat for a minute here?
Absolutely.
Yes.
Are you guys able to hear me? So in our rules and regulations, it actually is outlined on page 2 of our smoking medical marijuana pursuant to the provisions of Arizona Medical Marijuana Act and its associated regulations. Owners, their residents, tenants, or guests shall be prohibited from smoking marijuana, whether or not such marijuana is for medical purposes and allowed under the Arizona Medical Marijuana Act, on any portion of the association's common elements, whether in open space or an enclosed space at any time. Furthermore, owners, their residents, tenants, or guests shall be prohibited from smoking marijuana on any open space of their unit from which smoke can carry beyond the drifts of that unit, including but not limited to any balcony or patio.
So if they have their doors closed in their unit, they're okay as long as it doesn't seep out?
It seems like that's how it's going.
Yeah.
And that's actually why I'm attending, because we've got somebody who's smoking indoors, but it's going through the vents into other units.
Yeah, and that's the big issue is the ventilation. That seems like that's where people complain, is that it seeps through the systems. Well, that's interesting. I'd be curious. I mean, that rule, the way you read it, was, clearly created a couple of years ago when medical marijuana was the issue, and now that recreational marijuana is legal, sounds like that may need to be revised a little bit.
That's why I'm here.
If you want to capture that, and I would, that's interesting too, that the just again, that goes to my point of I don't know what your CC&R say, but I'm sure that they have some pretty broad rulemaking authority that allows you to impose a rule that, like what you just read, and that's great if you have that. My suggestion, Natasha, would be to talk to your attorney and see if how that can be revised in light of this new law. It probably needs to be, you need to maybe just take out the word medical, and make it more broad. But as far as the inside of the unit, if if the rule doesn't cover that right now, I mean, you could, if the document, like I said, if the documents allow for rules to affect the use of a unit, then you might be able to do it. Now, I say the word might because in a condominium setting, this is where it gets really difficult for us, is that so Arizona Revised Statute 33-1227 is the statute that governs condominiums and amending their CCNRs. And in subsection D of that statute, it talks about specific, I think there are 4 or 5 amendments to your CCNRs that if you do that, it will trigger a requirement of 100% approval of your owners. And one of those amendments is if you're going to amend your CCNRs, and if the amendment changes the way in which a unit may be used, that will require 100% of your owners. So for Natasha's example, if they had to amend their CCNRs to try to address this because the rules maybe weren't as broad, if they really wanted to clamp down on the interior use of smoking or of marijuana, they'd have to get 100% of their owners to sign off on that amendment. And I've never seen that happen. Even if your association was 20 units big, you probably still have one holdout that would prevent your 100%. It's possible, but just realize that in the condominium setting, amending your CCNRs for this issue is going to be nearly impossible because it will require 100%. So that kind of how I wanted to end that discussion on banning smoking, is that it can be done. And Natasha just gave a great example of how smoking can be banned. One of the questions before, I think, was about a resolution or an amendment or a rule. Again, that will depend on your documents. I have the most recent one I did was a rule through the rulemaking authority that we imposed a smoking ban on patios as a limited common element because the documents allowed us to do that. So we didn't have to amend anything. It was just through a rule and a resolution of the board. So we just have to take a look at your documents and see what they say. Now, some of the other language you might consider is banning all forms of cannabis. Just an outright ban on that material and the use of it. Now that could be a little more difficult because the law says they can have it, but it's this constant struggle or battle that the associations have between what the laws say and what we can do with our private property under the documents. And as you all know, documents can be more strict than what the law might say. And so I think if the documents allow for it, certain bans on activity would be defensible. Now, if it's a rule, remember, rules have to be reasonable whenever you create a rule. And so now that the law allows for this type of activity, you're going to need some other support to say that this is a reasonable rule. And that what I'm thinking of is just kind of the negative impact of the activity. Lots of homeowners complaining about the smell, just kind of the blight on the community, something like that's measurable, that might counter the argument that it's legal. And so it would be unreasonable to ban some sort of legal activity. But that's the struggle I think that we're going to have in trying to enforce this is that battle there on that issue. You might, if you don't want to ban all forms of cannabis, you might just ban certain types. Maybe because really when it comes down to it, I think the real problem here is the smoke. And so if you wanted to limit it to just the smokable kind, maybe you do that. You could place a ban on the growth of marijuana for those condominiums, and I focus a lot on condominiums because that's where this I think this issue is more prevalent. But some condominiums you might have shared utilities, electric water, where the association's assessments are paying that for the whole building. And even if it's just 6 plants inside of a condominium unit, I don't know how you grow marijuana, but I've seen pictures and seen movies where, you know, lights and lots of water are used, and it could drive up the electric bill. So if your units aren't separately metered, you could see a spike in that bill that could be directly attributed to that. So you might be able to, through the proper channels of your documents, be able to ban that type of activity because of that. Sale of marijuana or illegal activity, again, it's restricting the, just like documents do. Documents can restrict certain activity in the community, and so you might consider something like that for those two. Now, this one here on the bottom left, the banning plants or structures. I was thinking of that this morning. That, you know, a lot of plan communities have a certain type of allowable plant list. You know, what kind of plants can we plant? So I can't imagine, what people aren't going to be planting a bunch of plants in their front yard because as the law said, it can't be visible from the neighbors. So you're probably not going to have to worry too much about that, but you might consider it, putting that on the banned plant list. Structures, when I mention structures, I'm thinking of the greenhouses that are mentioned in the law, in the actual statute. And that would go towards your, what do your design guidelines say right now for your planned communities? What kind of structures are allowed? And that might be something where you need to go back to the drawing board as a board and maybe think of this type of situation. Do we need to expand the definition of the type of structures that we're not going to allow in the community? Just to be proactive, or maybe you think this is coming. So there's ways you might be able to handle that through your guidelines as well. So the last thing to look at, and this goes towards more of a broad discussion of what do your documents say as far as rulemaking authority. I have amended various sets of CC&Rs to one of the things that I identified in my review of the document was that your rulemaking authority was pretty poor, and let's beef that up. Let's give you some good rulemaking authority to help you maintain control of your community without having to take this to the owners for a CC&R amendment every time.
Quinten,
Yes.
there's questions about focusing on the smoking aspect, but there are edibles and other forms that also may be used in a common area or limited common area that they would not be aware of.
Mm-hmm.
And then another person asked, what would the liability be if someone becomes belligerent or has an accident in a common area or pool area after using edibles?
Yeah. So without question, the associations have the right to control what happens on the common property. So a lot of the stuff where I'm kind of maybe hesitating on certain bans or language, my mindset has been more towards the units. And I apologize for that. I should have mentioned the common elements a little more, common areas, especially common areas where association has 100% control. You want to, if you put in the rules that you want to see. So if you're concerned about the edibles, about any types of marijuana, then just put an outright ban on it. You have that right to create those rules, and that would be a rule-making thing. That wouldn't have to be an amendment to your CC&Rs. You have that right to create rules on your common area, so you could do that. And the liability question is a great one. If someone does become belligerent, or someone is high on marijuana and comes onto the property, I mean, that's why you want to have those protections in place. It might be a question that you want to talk to your insurance adjuster about, as far as coverage is concerned. But there could be, if you don't have prohibitions in place, you are liable for the activity that occurs on the common area, and so there could be some sort of liability depending on what happens, what the cause was. That there could be some liability there. So now you put these rules in place, like one of the questions said, it might be impossible to know if someone's actually violating that rule. But part of the point is to have that rule in place so that you have that protection. That we're making that effort to prohibit this activity. If someone chooses to break the rule and try to get away with it, well, that happens every day. But we have the rule in place for a reason, and we're going to ban this activity. So for those of you who have common areas, the pool areas, maybe in a condo, I would strongly recommend that you get rules in place that ban this type of activity in those areas, for the reasons we've talked about. And the language I have on this slide on banning the types of smoking or use or on the activity, you might consider beefing up your rules to govern those areas. Now, if your documents are silent on the rulemaking, which I have seen that before, there are ways that you can still create rules. You want to talk to your attorney about that. There's something called the restatement of property that allows associations to create rules against certain activity on the common area. But talk to your attorney about that. So this is not an exhaustive list. Obviously, this is just some ideas that I had thought of what you might do, and it stems a lot from things that I've tried in other communities through rules or document revisions. But I think that the takeaway for this is for as board members, especially, is to, like I said before, take a look at your current situation and review your documents and see what's missing, and then have that conversation with your attorney to find, hey, we are concerned about this law. What can we put in place in our documents, either through an amendment or through rulemaking that will properly address these concerns? And yeah, you have a lot of options. Yeah.
Kevin asks, what about the ADA, the American with
Yep.
Disability Act?
So that's you guys are very good here. Next slide, and this will be the last topic. We got about 10 minutes, and that'll be plenty of time here to go through this. So one of the things that I thought of, and this is because I've actually read some cases on this, is with medical marijuana, there was this concern about fair housing. I think the same is going to apply with just regular marijuana use, because for a lot of people, it's going to be the same reasons they're using it, and now they just don't have to worry about having a medical marijuana card. But I also think that it's going to be an opportunity for abuse, just like unfortunately we see with support animals, where people claim that they need a dog or 2 dogs or a ferret or something because they can't live without it. And many people, that's legitimate, but I think all of us have probably come across that person that knows the rules and knows how to bend the rules a little bit. Now, as far as the ADA is concerned, we don't really have to worry too much about the ADA when we're talking about associations, because we are not areas of public accommodation. We don't provide a public accommodation in most cases. Most of our communities are private for owner use only. Either the streets are private, but even with public streets, it's a private community in the sense that there's a set of owners that are bound by your CC&Rs, and it's only those people who own property in that community. So for 99% of the cases, the ADA is not an issue. But the fair housing laws are basically mirror a lot of what the ADA says. And so people throw out the word ADA a lot, but it's really the same analysis, and we can't just blow it off because someone might be saying ADA, the fair housing is going to jump in and take that place. So fair housing, I wanted to talk a little bit about why I think fair housing is a bit of a concern with this. Is as you know, the fair housing protects certain classes of individuals, and whether it's race, national origin. There's a statute going through the House right now, or I don't think it's been signed yet, but they're going to expand. I think I should say, I'm not sure if it's still going through, but at one point it was introduced that would expand the classes of people that are protected. And I think they introduced sexual orientation and gender, maybe one other, into this list of protected classes. The one that associations that we deal with the most would be disability. And that's why people throw out the ADA, because we're dealing with disabilities. And under this law, disability is about as broadly defined as you can get, where it's anything that's going to impact one of your major life activities is kind of my way of paraphrasing it. I bet almost every one of us on this call right now could think of something where we might be able to claim a disability under the Fair Housing Act. I don't make light of it. That's just the way it's written, is that it's very broad and can encompass a lot of stuff. So many people, whether it's a sickness, which could be a disability, maybe it's a mental concern issue, and maybe they're prescribed marijuana as a remedy or a cure or prescription, a medicine for that condition. And fair housing laws don't really affect us unless we have a law or we have a restriction in place that prohibits certain activity. And they want to be able to do what would otherwise be a prohibited activity. And their basis for doing that is because they have a disability. That's where this comes up. So in your community, if you have an outright ban on smoking or a ban on smoking in certain areas, you might have a homeowner that comes up to you and say, hey, I'm disabled. My doctor says that I have to smoke this marijuana every day for my disability. You have to provide me with what's called a reasonable accommodation. You have to allow me an exception to the rule. Everyone else has to abide by it, but this individual gets an exception under the law. Now, when you get that request, first thing I tell all my clients is talk to your attorney, because fair housing violations are very easy they occur more frequently than you know. And the Attorney General's office loves to go after associations for this. I'm defending an association in federal court right now over a fair housing violation claim. It happens. So, but I wanted to go through just so you have a quick understanding of the analysis that goes into these decisions. And the decision being, does the board have to allow this person to smoke medical marijuana where they want to, or can we continue to restrict it against this owner? And the first one is there a disability? Now that's a delicate situation. We can't ask too much from the owner. You might not really know that this person's disabled, so you can ask for a doctor's note that confirms that the person is disabled. And that doctor's note is also going to need to make a connection. I put the word nexus, that's the legal word, a connection between the disability and the activity that they're asking permission to participate in. In this case, it would be smoking the marijuana. If they present you with that, then the next analysis is you kind of establish the necessary aspect of it. That's the nexus. It is necessary for me to smoke marijuana for me to be able to enjoy my property. The last analysis is whether the request is reasonable. Now, we may not think it's reasonable because we don't want marijuana in the community, but that's not the analysis. The analysis is whether it creates a financial hardship on the community or it's a fundamental alteration to your operation. Now, there's two cases I wanted to mention here that actually went into this analysis that I found on medical marijuana and whether it's a reasonable accommodation, whether we have to provide that. There was a case out of Washington from, this is almost 15 years ago now, where a homeowner asked for a reasonable accommodation to be able to smoke marijuana. And the court denied their request on, I think it was on two issues here. One is that under federal law, as I mentioned in the beginning of this presentation, marijuana is still illegal. And the fair housing is very clear that you do not have to provide an accommodation if it involves illegal activity. And so they said that the housing authority in this case was okay in rejecting it because we're not going to force the housing authority to break federal law. Now, where this gets a little tricky in our situation now is state law says it's okay. And there's a state fair housing law as well as a federal. And so if someone brings a claim under the state fair housing laws, we may not have that argument that it's not reasonable. Not that it's not reasonable, but it's because it's illegal. So the other case that I found out of Michigan, this is kind of an interesting one. It's a condominium association in Michigan where a homeowner was complaining about her neighbor smoking, and it involves cigarettes and marijuana and a whole bunch of other smells, and demanded that the association do something about it. That, you know, as I'm sure all of you have experienced, one homeowner like, you guys aren't doing enough. You need to do this, you need to do that. I can't live here anymore. It's causing health problems to me. So the association, they tried. They actually went into her unit and installed a new ventilation system for her that would try to draw air from another part of the building. That didn't work. So then she demanded that the association amend their CC&Rs to prohibit smoking outright. And they tried. They actually sent out a ballot to all the owners to amend their documents, and it failed. And so the owner sued the association and said, You're not doing enough. I need this accommodation. And her accommodation was, you need to restrict what other people are doing for my own health benefits, which is kind of a creative use of the fair housing laws. But the court, when looking at it, realized, look, this isn't a reasonable accommodation. We can't force the association to change its documents. There's still a procedure that they have to go through to amend their CC&Rs, and it's not reasonable to impose that on the association. And there were some other factors that went into the analysis, but the takeaway was it's all about that reasonable. That would have been a fundamental change in their operation as an association. They would have had to have changed their CC&Rs. So kind of the takeaway from fair housing is that don't be surprised when you get this request. I think they're coming if you haven't already experienced it. I haven't actually seen one involving medical marijuana yet, but I'm sure they're out there. And just be careful with if it is a request for an accommodation for smoking. You might be able to limit it to certain locations. I mean, there might be ways around this. There could be creative solutions we could come up with in response to it. But get your attorney involved if you do get one of these requests, because they can be it can be a painful, expensive lesson if you don't do it right, because there can be some steep penalties for violating the fair housing laws. So
We do have a couple questions.
okay.
So going back to the common areas, Leslie had asked, since the common area is a public area, wouldn't that be covered by law enforcement? Meaning, could they just call the police if someone was using marijuana in the common areas out in public?
No, because I don't think the police are going to touch it, because it is still private property. It's still the association's property. They might. I mean, that's a good question. I don't know the exact answer to that. I mean, you're as property owned by the association, you could still regulate it. Now, one thing that made me think of is open space. So going back to the law, the marijuana law, it does prohibit smoking in an open space, and that's defined as a public park, a public sidewalk, a public walkway, or public pedestrian thoroughfare. So I don't think that common area is going to be, in most cases, would be deemed a public park, because it's not open to everyone. Now, the sidewalk might be if they're smoking on the sidewalk. So it's one of those things I'd be interested to see what the cops do if you did call the cops and see what kind of response you'd get. I'd love some follow-up on that to see if it was actually effective. But if you're dealing with your common property, it more than likely is going to fall on the association to deal with. For that.
Okay. And Amber, and I believe you covered this already a little bit, but Amber was asking, what if someone is smoking in their own unit in a condo and the smell's traveling through the vents? What stance does the association?
Yeah, that's the most common issue I think we're going to face as associations, and probably the one that you don't have the best answers, because some of this we've talked about with the CC&Rs and the rules. You may not be able to create rules that prohibit that type of activity. You may have to allow that activity to take place, but you do have this slide that we talked about a nuisance. Even if they're allowed to do it, does not mean that it's not a nuisance. So if you have enough homeowners complaining, if it's affecting these homeowners enough to where either they're going, they've got to move out, they had to go to the hospital, there's probably a claim there that you could restrict the activity because it's a violation of the nuisance provisions of your documents. If you don't have nuisance language, you could amend that as well, or you could amend the current nuisance language that you have to try to beef it up. But you have to be careful with amending that. You couldn't use kind of a backdoor restriction on the use of a unit. You'd have to be broad as to what a nuisance is. But I think whatever, if you have that language in there right now, you probably have enough to go on for that scenario to try to get the activity to stop. But there's no guarantees there, and it could be a tough battle. And part of it too is it becomes an owner to owner type issue. One of the cases that I shared with you was an owner had to take her neighbor to court over the issue, and it didn't have to do with the association. So that might be where it goes to. You might be able to only do so much as an association, and the owner may have to take the matter into their own hands.
Ramiro wants to know if we can post signs at pools to restrict all types of smoking, including vaping, and then update the rule book, which takes longer to update and hand out to all owners.
Well, I think the answer to that question is yes. If you have a rule that prohibits that activity, you could put signs up. Again, it goes back to what do your documents restrict? What do they allow you to restrict? And then you just take steps accordingly after that to make it known. Now, as far as updating your rules, if you revise your rules, you're going to need to get a copy out to the owners ahead of time, just to make sure they're aware of it. And I'm hoping that answered your question, Ramiro. I mean, you can shoot me an email offline if you want to, but any other questions? Sorry if I skipped over some of that stuff. I get going sometimes, and I sometimes forget to say some of the stuff I want to say, but really good questions. Like I said, the handout that I gave you should cover pretty much everything we talked about today. If any of you have any questions after this call, email Terry or email me. I think I've got on the last slide here. Yeah, there's my email address. Feel free to just send me an email. I'm happy to give you a quick response. Even if I don't represent your community, I'm happy to try to answer your question. And then so for the CLE credits, if you're still on, I hope everyone's still on. I forgot to do that earlier. The last code is the color green. So the first code was 420. The second code is green. So for those of you who need CLE credit, please email those 2 words, or I guess the number and the words, to Terry, and she can get you your certificate for the class.